on you to read a wonderful book written by the one and only Michael Slater. He has come with a book called The Tyranny of Merit, where he speaks about the unequal distribution of values in the American society and the access to higher education institutions. He uses two words: stalled social mobility and entrenched inequality. Look at these expressions: stalled social mobility and entrenched inequality have been the bane of American society and higher education institutions. And he says in this book, the book deals with, in fact, the hubris meritocracy generates among the winners and the harsh judgment it imposes on those left behind. See, because the crowd loves the winner, and the meritocracy system, remember, generates hubris among the winners and the harsh realities of the people who are left behind. Most of you must have seen the film 12th Failed. That's a testimony of the whole thing. I need not speak to you about that. Okay, isn't it? You have dire consequences in the American society today. And he says, in the globalized economic world, what is morally right is left out in favor of what is in the best interest of the economy. What is morally right is left out in favor of what is in the best interest of economy. And this is where the constitutional morality, this is where the transformative constitutionalism and the wholesome doctrine that the Supreme Court has given to us will come to the succor and the rescue of the common man. Please remember, your teachers might have told you that the Constitution is assailed as a lawyer's paradise, the Constitution of India. But the working of the Constitution has proved that common man is the central theme of the Constitution of India. And if the working of the Constitution has proved that common man is the central theme of India, it is no less due to the activistic forays of the Supreme Court of India and the dissenting opinion of Justice Lalit in the 10% EWA judgment is a masterpiece. And I'm sure what Alan Barth calls, he would become a prophet with honor in future. Because the 10% EWS reservations have excluded scheduled castes and OBCs, and Justice Lalit has given the dissenting opinion. Can you have a better person than Justice Lalit to expound the philosophy of compensatory discrimination, to initiate you into the realms of protective discrimination, or affirmative action programs, as they are called all over the world? And therefore, it is my privilege to use extend a very warm welcome to you, sir. Here I am to listen to your erudition along with my students. So permit me to be in the audience to listen to you. Welcome. Thank you very much.
Professor Rao, all the distinguished members of the faculty, the students who I've been told are a mix of undergrad as well as postgrad students, ladies and gentlemen, it's a privilege to be here addressing you. I demitted office sometime in November 2022, and since then I've been pursuing my third innings of the life, which is to be a professor in law. I do not have any post-graduation degree, so therefore I didn't know whether I'll be competent enough or eligible enough to be giving lectures like this. But fortunately for me, I keep giving lectures at 4 institutions, including Bombay IIT, and teach them certain courses. So therefore, it's not just one-off lecture. I give lectures which span for about, say, 15 or 16 lectures to complete a course. And it has been a journey of pleasure, a privilege, if I may say so. And that's how I'm before you to give one lecture on this affirmative action. But before that, just 2 observations. Professor Rao mentioned about Dharma Shastra, constitution as Dharma Shastra. There's a very beautiful quote by Justice Krishna Iyer in that Mahajan's matter, where he says that if you understand dharma of the constitution, karma of adjudication will be simpler. Very beautifully put. If you understand the principle, the underlying theory of constitution, dharma of constitution, all subsidiary issues like karma of adjudication become simpler. Then the second observation which I would like to make, and I can't just let go this opportunity. If a person has 2 PhDs and he is pursuing the 3rd PhD, to the best of my knowledge, Ambedkar had 4 PhDs. One from Columbia University, the second from London School of Economics, the third again from Columbia University, and the 4th from Osmania University. The first 2 were earned as a student. The last 2 were conferred honoris causa. So if you are earning even the 3rd PhD, that's something remarkable, sir. Very well. Now we'll come to our subject, which is affirmative action under the Constitution. Can I have that slide which I gave you? That's okay. Can I give lecture like this rather than being confined to one place? So what is affirmative action? The expression was used by John F. Kennedy for the first time sometime in 1961. And that is to say that set of measures which are contemplated, undertaken and extended under the constitutional jurisprudence, under the provisions of the Constitution, so that certain disadvantaged sections of the society are given a helping hand to come up to certain levels. Yeah, that's it. What we normally see is that Article 14 has 2 facets. Number 1, formal equality, that everybody is equal in the eyes of law before the provisions of law. And the substantive equality, what we see is that yes, the Constitution must also recognize that yes, you can uplift certain persons so that there is a equal kind of level playing field. Imagine a lady or even a parent having 2 children, one 5 years and the other one just a toddler who has just learned to walk 1.5 years. If they are crossing a road, how would they cross the road? Normally, the parent would hold the hand of that 5-year-old child because he can walk on his own. And the toddler who is just about 1.5 years but has learned to walk, but takes gingerly steps, will be held in arms. So that kind of protection which is extended by a parent is the same idea in loco parentis kind of extension of that principle, that the state extends a helping hand to somebody who is as compared to others in a disadvantaged situation. That essentially is our affirmative action under a constitution. So in this lecture, I'll take you through the steps which were undertaken till the framing of the constitution. That's a journey which starts with Mahatma Jyotiba Phule way back in 1861. and right up to 1950. And then from 50 onwards, what is our constitution contemplated and how the problems which arose were tackled by the parliament or by the Supreme Court at every juncture. There have been cases where perhaps one can say that there was a tussle between the judicature on one side and the parliament on the other. So we'll just run through that, because in a lecture which is just about 2 hours or 2.5 hours, we will not be able to go through every bit of that provision, but I'll just take you through this journey. This is what normally they say, tracing the fruit to the roots, and that's what the idea which comes in various speeches and various works. Jyotiba Phule was a person who started for the first time schools for what are called underprivileged. And so much so that when he was feeling short of hands who can teach, he first taught his wife. The wife was also an equal participant along with Jyotiba Phule in all their pursuits to teach the underprivileged children. In those days, a lady would not be sort of getting out of the house or household. So that lady, Savitribai Phule, used to be taunted, used to be harassed, even the stones used to get pelted on that lady. And it is through this kind of difficulties that the journey of this couple began. And they were adamant, they were steadfast in their approach, and that's how they started having what is called the first kind of approach where the underprivileged children could be taught the basic education. Because in those days, Shudras were completely out of what is called the educational system. In the schools of Dronacharya, Eklavya did not have any place. That used to be the approach, that the education was confined to certain higher levels of the society and not available for what is called the downtrodden. So that was the first approach which was done at a private level, and this is what is addressed to the Hunter Commission 1881. And what he then said is that after having gone through that, he suggested that let there be some reservation for some of these persons coming from that strata in the employment opportunities. So therefore, this is what he advocated for the first time. And one of the most glaring tendencies of government system of high-class education has been the virtual monopoly of all the higher offices under them by Brahmins. This is exactly what Professor Rao also indicated. Do you know this? In Karnataka, the population of Brahmins to the entire population of the society was just 3%. But the jobs which were dominated by them and cornered by them were more than 80%. So therefore, look at the unequal situation that 3% people are dominating to the extent of almost 75-80%. And that was one of the reasons why, as we progress further, that we will find that Mysore Maharaja was also sort of concerned about that particular facet of the matter. If the welfare of the Rayat means the common man, Rayat is at heart. It is the duty, if it is the duty of the government to check a host of abusers, it behoves them to narrow this monopoly day by day so as to allow a sprinkling of the other castes to get into the public services. This is what was advocated by Jyotiba Phule. Then comes a significant step, which was in 1902. See, Jyotiba Phule, it was his idea, which as an individual he was advocating, projecting as an idea. But where was the government apparatus? The government apparatus was not behind him. The government apparatus had not acknowledged that as a principle or as a policy for extending certain benefits. This is the first time that some sovereign accepted that as a principle and then started projecting as the element of public policy. So Kolhapur Maharaja, and do you know this, who had financed the education of Dr. Ambedkar in all these foreign universities? It was this Kolhapur Maharaja. So therefore, a man who was golden heart and who always wanted the downtrodden from the society to come up and have the fair share in the entire administration. This is Kolhapur Maharaja. This is the original in Marathi. I have the translation, which is the next document. Translation as published in the volume Rajarshi Shahu Gaurav Granth by the Government of Maharashtra. Proclamation of reserved seats for backward castes as published in the Kolhapur State Gazette. Now what it says is this. Currently in the Kolhapur princely state, steps have been taken to educate the people of all Varnas and to educate them towards education. Encourage them towards education. However, looking at the condition of the underprivileged, the government feels sorry that these efforts haven't had the kind of success that was expected. After thinking carefully about the subject, the government has reached the conclusion that there aren't enough opportunities available after completing one's higher education. As a solution for this, and to encourage the backward classes or Varnas of the government subjects to opt for higher education, His Highness has decided that a higher portion of the princely state's employment opportunities should be kept aside for these classes. Now mark this next. In this regard, His Highness orders that of all the seats that go vacant from the date of this proclamation, 50% should be filled with the backward classes. In all the offices where backward class employees number less than 50%, all the next appointments should go to the backward classes. So two principles. Number one, reservation was first advocated in 1902, accepted by the sovereign, and became the policy in that princely state of Kolhapur. Second, which very late somebody thought of having what is called backlog vacancies. Wherever the number is less than 50%, all the appointments must go to the backward classes. A different facet of that, but as we progress, I'll be able to point out what exactly are backlog vacancies and to what extent, and what had been the approach of our parliament while dealing with that particular subject. After the publication of this order, the chiefs of each department should send a tri-monthly report of all the appointments in their departments to His Highness. Note, the backward classes should be understood as all classes except Brahmins, Prabhu, Shainavi, Parsi and other advanced classes. Mind it, mark this, 1902, nobody had ever undertaken any survey, any kind of analysis as to how many backward classes, which are backward classes, what is their percentage, what is their number, and what is their assessment or advancement in life. It was a generic idea, but this idea was for the first time somebody came out with this idea and started implementing it. Then comes Indian Councils Act, Morley Minto reforms. One of the ideas of these reforms suggested separate constituencies. Separate constituencies for Mohammedans, separate constituencies for Christians. So therefore this was the idea. So therefore one part, because what is affirmative action? Affirmative action is to do what? To say that certain sections of the people of the society or of the society are so low at the level of hierarchy that you need to give them compensatory kind of treatment. Compensatory treatment will be normally under three heads. Number one, we'll try to give them share in political power. Because what happens is, normally Shudras were never part of what is called the power structure. Never. Who were the kings? Who were the persons who would be running the administration? Naturally, Kshatriyas, or to a certain extent Brahmins. Peshwas were all Brahmins. There were certain kings who were Brahmins. Some of them came from Vaishya category. Like, some princely states in Kerala, they were from Vaishya category. But never a Shudra who was a king at any juncture. So therefore, in order to uplift a particular society or a member or section of the society, you need to give them representation in political structure. Because it is through that political structure that you actually give them sense of comfort that yes, I am also part of the administration. So therefore the first part was that to give representation. But unfortunately in this Murle Minto, it was not on the ground of compensatory affirmative action. It was essentially on the religious ground. They felt that perhaps, I think, there are a sizable number of Muslim population, there are a sizable number of Anglo-Indians and Christians who are living in this country, and therefore there must be separate reserved categories or reserved kind of constituencies for them. So the seeds were sown here in 1909. Minto directly introduced the elective principle of membership in the imperial and local legislatives. Separate electorate is the idea, which was then. Do you know how the separate electorate principle used to work? Today what we have is a very modified and refined version of that idea. What we have is, when it comes to elections to Lok Sabha or to legislatures of a state, what we have is separate constituency, where persons who come from that category may be scheduled caste, scheduled tribe, and today now, as a result of representation or reservation for women as well. So therefore, only those persons can be contesting as candidates from that particular constituency. But who are the voters? The electoral college comprises of everybody, regardless of your caste, creed, religion, etc., etc. In this idea, it used to be that only those persons coming from that category alone would be entitled to elect those persons. So it was not just separate constituency, it was separate electorate as well. This perhaps was the reason some of the thoughts, pardon me, which you will find in Constituent Assembly debates, that perhaps was the reason for the partition of this country. Because what happened is, in cases where there were separate electorates, separate constituencies, those persons never used to bother about what is the general consensus or the feeling of the rest of the members of the society. So therefore that is where the segregation started. So therefore some of the social scientists actually say that the segregation, the roots of partition were sown in this particular reforms idea. But this was not for the upliftment of scheduled caste, scheduled tribes, and that is the reason why, as we go forward, we will find the second roundtable conference where Ambedkar was agitating that. Then Miller Committee, a report to be read with note of qualification by so and so. Miller Committee was constituted by Krishnaraja Wadiyar, a Maharaja of Mysore. Terms of reference. The government order states that there is at present a large preponderance of the Brahmin community in the public service, and that it is the desire of the government that the other communities in the state should be adequately represented. A committee was appointed to investigate and report on the question as to what steps should be taken to encourage the members of the important communities other than the Brahmin community to seek employment under the government in larger numbers. The specific questions were changes needed, if any, in the existing rules of recruitment, special facilities to encourage higher and professional education, any other special measures which may be taken to increase the representation of the backward communities in the public services without materially affecting the efficiency, due regard being had also to the general good accruing to the state by the wider diffusion of education and a leading of increased status, which it is expected will thereby be produced in the backward community. The recommendations. Within a period of not more than 7 years, not less than half of the higher and 2/3 of the lower appointments in each grade of the service, and so far as possible in each office, are to be held by members of communities other than the Brahmin community, preference being given to duly qualified candidates of the depressed classes when such are available. The right course to ensure a larger appointment is to take the existing proportion of Brahmins to other communities in each grade of appointments, together with the percentage of those communities to the total number of appointments in each grade, and reserve as many as appointments in that grade as may be necessary to secure a progressive reduction of inequality in each year, etc., etc. So mark this, as against Kolhapur Maharaja, now there is a further refinement. That very well, let's work on the percentage and try to bring the principle of equality. Recruitment to public services. So therefore these are just the ideas that somebody should be between 25, 28. Let's not bother ourselves with that. Steps may be taken to bring out equality in secretariats in 3 or 5 years. Then comes the Government of India Act. And this is something, what actually it introduced is, number one, this one, gave women the right to vote. Do you know the distinction between when we say we the people in the preamble? When we adopted our constitution, we the people meant every single individual in this country, regardless of color, caste, creed, religion, community, etc., etc. But when Americans said we the people in their constitution, African Americans were not included. 17% of their population was still under slavery. Naturally, they never had what is called civil rights. So the expression we the people is more stronger, more powerful in our constitution. Women did not have right to vote when American constitution was adopted. So therefore this is where what we get is 1909, it gets women the right to vote. It introduced what is called diarchy. And diarchy means that the government at 2 levels, the state or the provincial level and the federal government. So it introduced for the first time that principle, which then gets carried in our 1935 Act, which was then got translated in our constitution. This is very interesting. There's in Madras province, a particular party came to power in the provincial government elections. And one of their charters was, can this be expanded a bit? Can this be? Just, I want just this much. It's very difficult to read, but yes. I just want this to be expanded. This is a Gazette notification. Let's try to read this. In order to increase the proportion of posts in government offices held by non-Brahmins, the government directs that that's right. The principle prescribed for the revenue department in both standing orders, so and so, on the subject. Now you've just gone slightly, take it to the left, please. On the subject of distribution of appointments amongst various castes and communities should be extended to appointments of all grades in several departments of government. All heads of departments and other officers empowered to make appointments are requested to adhere strictly to this principle in filling up vacancies in future. Heads of departments, collectors and district judges are requested to submit to government half-yearly returns showing in respect of their own offices and the subordinate offices under their control the number of men newly entertained in the permanent service during the half year and classifying them under the following heads. Now mark this: Brahmins, non-Brahmin Hindus, Indian Christians, Mohammedans, Europeans and Anglo-Indians, and others. So this is what, for the first time, the government of a state started saying that let us have seats which are allocable or allocated to certain communities. This is what then started off. So this is in 1921. Then comes another which is very crucial, which is, can we just have the regular one? Yeah, that's right. This is 1931 Second Roundtable Conference. You know, Mahatma Gandhi went to attend this roundtable conference, and Gandhi used to consider himself to be the champion of Harijans and their causes. But there was one more person who attended that conference, that was Dr. Ambedkar. And his ideas to uplift the lot did not exactly coincide with Mahatma Gandhi's ideas. Ambedkar started advocating what is called separate electorate principle, which was till then available for Mohammedans, Christians. So he said, why not for scheduled castes and scheduled tribes, separate electorates? Gandhi said no, and Gandhi actually, after this, 1931, he went on a fast in Pune, which is called, he was on fast for 21 days. And that was Amaran Uposhan. According to him, separate electorate is not something which is good for the society. You can have constituencies reserved, but please don't have separate electorates. So therefore, on that principle, these two great personalities struggled to come to a meeting point. And after 21 days of fast, Amaran Uposhan, Ambedkar relented and accepted something in principle, which then became what is called Pune Pact. And Pune Pact is considered to be the foundation for the concept of reservation under our constitution. Pune Pact, an extension of communal award as so and so, so and so. Very well. Now what is Pune Pact? There shall be seats reserved for depressed classes out of the general electorate seats in provincial legislatures. Election to these seats shall be by joint electorate, subject, however, to the procedure. What is that? All members of the depressed classes registered in the general electoral roll of a constituency will form an electoral college which will elect a panel of 4 candidates. It's actually 4, not 2. 4 candidates belonging to the depressed classes for each such reserved seats by the method of single vote, and 4 persons getting the highest number of votes in such primary elections shall be the candidates for election by the general electorate. Let me just explain this. The election would be at 2 levels. Number 1, only scheduled caste and scheduled tribes would form the electoral college. They will elect what is their choice, 4 persons. So supposing in case you have A, B, C, D, E, F, G contesting the elections, they may elect A, B, C, D. E, F, G get thrown out of consideration completely. It is this A, B, C, D in the second round of election will be the contesting candidates, where the general electorate will now be electing 1 out of them. So it could be C, it could be B, it could be D. But the general electorate would not have a chance to say that look here, those EFG were actually the better candidates. So why not elect G or H or E? Sorry, you won't have that kind of chance. Your chance or your options are restricted to A, B, C, D. This was the logic which was accepted under Pune Pact. So what happened is, Ambedkar's idea that, I must have a choice in selecting who shall be my representative. Because perhaps it could be that a pseudo candidate, a dummy candidate could be fielded by the general electorate, and then scheduled caste will be completely sort of, dominated, those communities will be dominated by certain Savarna groups. So he wanted the idea that yes, we must select who shall be our representative. Gandhi's idea was no, separate, no electorate separate, but what you can do is general electorate must elect somebody from the community. So it was a meeting point for both these personalities. This is what Pune Pact was. Again, this is the same principle which was at the central legislature. Then comes Government of India Act. This principle which was Pune Pact was sanctified by Government of India Act. So it became what is called the constitutional norm for this country. That when it came to separate electorates, this shall be the idea. Same principle would apply to Mohammedans, same principles would apply to Christians. The Government of India Act had three communities in mind. Number one, Mohammedans. Number two, Christians, which would include Anglo-Indians as well. And number three, scheduled caste and scheduled tribes. But going by what? The principle is what was adopted in Pune Pact. So therefore, you will have first primary election, you will then have the second election, which is supposed to be the main election. Something like what you have preliminary and main examination in civil services. So something like that. Very well. Then comes Viceroy's Executive Council. So there were elections and persons were elected. It is those representatives which form what is called the Constituent Assembly. And then comes the Constitution. Very well. Now we have covered the journey right up to Constitution. What happened in the Constitution? There was a draft article which was draft article 292, which was bodily lifting of the idea under 1935 Act that let there be reservation for Mohammedans, let there be reservation for Christians, let there be reservation for scheduled castes and scheduled tribes. Of course, when this draft article was drafted, it was sometime in 1946-47. So we did not have the agony of partition which was at the back of the mind. But there are documents which show, and Constituent Assembly debates, that after having gone through the agonizing period of partition and what was the aftermath of that, some of the founding fathers then started saying that, we have committed a mistake, perhaps. And there was the retracing of the idea, and one of the very strange feature of the Constitution is that in a sudden kind of turn of events, Ambedkar proposed a substituted article for 292, which did not have reservation for Mohammedans and Christians, but only for scheduled castes and scheduled tribes. There is no discussion why this step was undertaken, that why are you dropping this? But there is just, Ambedkar says that in my view, substituted article should be this, and the entire assembly then adopts it. What has the Constitution then adopted as a principle? According to me, it adopted in 1950 three ideas. Number one, share in political power. That came under Article 330, which is to say that for scheduled castes and scheduled tribes, there shall be reserved seats and reserved constituencies in proportion. What proportion? Their proportion to the general population. If the scheduled castes are 25%, 25% seats shall be reserved, there shall be reserved constituencies. Why? Because then you want them to have share in political power. The representatives will be coming from that particular strata. They will certainly be aspiring to have the development of those societies at the back of their mind in their approach every time. So the first and foremost is 330, which is for Lok Sabha, 332, which is for state legislatures. So therefore, at every juncture, whether it is the state legislation or whether it is the union legislature, the reservation of seats which is contemplated is that. Then you have companion articles which are from 330 onwards as to how the approach has to be done. So therefore you have 341, you have 342, that who shall be the persons concerned, what is the modality. So machinery provisions are from 330 onwards, that there shall be a commission, there shall be periodic review, there shall be periodic assessment, and the president shall then notify, keep on notifying the parliament. The initial order is by the president under 341, subsequent modifications etc. by the parliament. But the underlying idea is what? Separate constituencies. This logic of two-tier elections, which was the idea under Pune Pact and the Constitution and the 1935 Act, was given a go by completely, and what we have is one single election. The only thing, distinguishing feature is that those persons who come from that community alone can be the contesting candidates. But the electoral college will be general electoral college. So this is one part which is out of the tripod. The first part is this. The second part, and this is where the debates in the Constitution actually show you that if you're thinking in terms of upliftment of certain sections of the community, the basic part is education. The basic part is education. So therefore, you must extend that helping hand so that all of these persons attain certain levels of education, they uplift themselves. What is normally taken is tamasoma jyotirgamaya, asatoma sadgamaya. So it's the travel from darkness to the enlightenment, to the principle where we all get what is called the flame of education. So therefore came what is called Article 15, which is the educational opportunities. Then the next one, that if you give them share in political power, but people are not sort of concerned with members of parliament and members of legislative assembly every day. The interface of the society is always at the lowest levels, starting from Tahsildar or a police sub-inspector upwards. And if you want to really uplift the society, then just as what Mahatma Phule had advocated, just as what Mysore Maharaja did, we must have some reservation in public employment. And therefore, the idea which germinated in the form of Article 16 is to give share in public employment. So we started a constitution with this tripod of idea: share in political power, share in public employment, and educational opportunities. And this is where this tripod or this idea would be taken as a basis for uplifting the entire society. Very well. Who were those classes? Scheduled castes and scheduled tribes. Initial idea, scheduled caste and scheduled tribes. So if we think in terms of who are the beneficiaries of this affirmative action, scheduled castes and scheduled tribes. Minorities, not the way 1935 Act had done, not the way Article 292 in the draft constitution wanted to do. No separate electorate, no reservation in public employment, no reservation in educational opportunities. But our approach towards minorities has been that yes, you have every right to go ahead, establish, administer institutions of your choice. So therefore it was more of what? Acknowledging the right of such institutions or right of such minorities to set up institutions of their choice and educate their own people. but it was not a positively affirmative act which was supposed to be extended in favor of these minorities. So therefore, the beneficiaries, according to me, of this particular action, affirmative action under the Constitution, initially drafted, was only scheduled caste and scheduled tribe. Very good. So this was 1950. You saw that Madras idea 1921. After that 1921, in Madras province, there used to be, when it came to educational opportunities, what is called communal geo. So it was, a reservation was strictly on the basis of communities. For Brahmins 2 seats, for non-Brahmins 2 seats, for scheduled caste 2 seats, for Christians 2 seats, for Mohammedans 2 seats. This is how it used to go. That was the approach of Madras legislature, because they felt that this is the only way in which we can have diversity in educational opportunities. So this was the ruling kind of, the regime in Madras. As a result of which, one lady called Champakam Dorai Rajan, who wanted admission in medical school, was deprived of that. She came from forward community, Brahmin, but according to her, because of this reservation in favor of certain communities, the seats got sort of lesser for the meritorious candidates, and though she had secured more marks than the persons who got admitted in the slots which were reserved for certain other communities, she, as a result of working of this GO, was deprived of opportunity. Similarly, there was one candidate called Srinivasan who wanted admission in engineering college. Again, the same fate, he was also denied. These two persons challenged the communal GO by filing a writ petition in the Supreme Court. And the judgment is by 5 judges of the Supreme Court in Champakam Dorai Rajan. What did they hold? They said, and mind you, in those days, the initial constitution had 15.1, 15.2, 15.3. Article 15 stopped at that level. 16 had 16.1, 16.2, 16.3, 16.4. So, therefore, 16.4 contemplated what is called reservation in public employment. But there was no specific article which contemplated or spoke of a reservation in educational institutions. So the theme which the Supreme Court went by in Champakam Dorai Rajan Constitutional Bench, they said, unlike 16.4, there is nothing in 15 which says that seats shall be reserved in educational institutions. Second, 29.2 says that if an institution is receiving aid from the government, then there shall not be discrimination when it comes to educational opportunities. So how can you now make a distinction and say that seat shall be reserved for communities? That goes against the very basic tenet of Article 14. And therefore communal GO was struck down. That was close on the heels of Constitution getting enacted and being sort of, coming into force in January. And that's the immediate response, which is the First Amendment of the Constitution. Among others that the First Amendment contemplated and dealt with, one was this issue of 15. So the response, and very beautiful passages which are Pandit Jawaharlal Nehru speaking in support of that amendment, and they actually show the indignity on part of some of the members of that assembly, saying that how could Supreme Court do this? What is the basic idea of 15.1 is something that which gives special kind of dispensation, it empowers the state. Why can't we do reservation? Very well. If the Supreme Court says you can't do, let us have a separate article provision which gets incorporated in the Constitution, and that is how 15(4) got included in our Constitution. So therefore, see the response of the Parliament, so immediate, so clear, so precise, that this is what we want to do by way of affirmative action, and therefore this is where we will certainly go that whole hog. Now, very, some of the works which have been actually on the point, they describe this as, which was that assembly which passed this First Amendment? It was the same Constituent Assembly. Because by that time, the first Parliament had not actually, been put in place. Our Representation of People Act is of 1951. The first elections took place in 1952. So this Constituent Assembly, which had given us the Constitution after so much of deliberation, was the same chamber which thought of the First Amendment. So therefore, all the more reason that it was in their contemplation that, look here, this is what we contemplate by Article 15. And if this is the reading of the Supreme Court which is now getting put on that by way of interpretation, then we must remedy the situation. So therefore, people always consider First Amendment to the Constitution to be part of the original Constitution, because this was done by the original chamber, original founding fathers. Nobody else overstepped at that juncture. So very well, 15(4) got included. As a result of that, what? Now you can have reservation in educational opportunities, educational institutions as well. Very well. So we started with that. Now the tripod has an additional feature, 15(4). Good. Then comes, in 1880, Bundle Commission was put in place under the executive order passed by the central government. Do you know this, that this Hutton Commission, there was one commission in 1931 which had for the first time undertaken, I mentioned here that in 1861, 1881 when Jyotiba Phule tried to say that certain seats be reserved, what proportion? Constitution also says 330 in the same proportion as their population bears to the general population. Who knows that percentage? What is the basis? In 1931, Hutton Commission was set up by the British government to have a first-hand analysis for the first time which was undertaken to see that which are the communities which in the societal hierarchy or ladder are at the lowest level. So who are Shudras? Who are what is called underprivileged? What is their percentage? What is their number? So Hutton Commission for the first time undertook that exercise. Recently it was state of Bihar which did it for the first time since 1931. So from 1931 right up to 2023, nobody had undertaken any analysis. So what is it that we went by under 330? We simply went by proportion. If according to Hutton Commission in the state of Bombay, which was the original state or province of Bombay, proportion of scheduled caste to the general population is 17%, so shall be taken as 17% even in 1950 and thereafter. They're still continuing with that proportion. That's why the consensus, which is the census which has been now sort of ordered by state of Bihar, assumes a greater significance. Very well. So therefore, in the normal hierarchy, what we had was Brahmins, Kshatriyas, Vaishyas and Shudras. Who are Shudras normally? Among Shudras, the lowest levels are untouchables. But all Shudras are not untouchable. There are some of the Shudras who are not in that category as untouchable. See, some of the menial jobs which were being undertaken, that is to skin a dead animal, and they take out that particular skin, convert into hides, into leather, used to be the jobs which were traditionally done or executed by a community called chamars everywhere. That would be a community which was the untouchable community. The manual scavenging community, that was the untouchable community. So therefore, such communities were, even amongst the Shudras, were considered to be untouchable. But all Shudras were not. Similarly, there were certain communities in Vaishyas which were doing the lowest of the jobs, but they were not scheduled castes. So therefore, in order to understand whether apart from scheduled caste and scheduled tribe, are there any communities which also require affirmative or compensatory action, the commission was appointed under the orders of the central government in 1980 called Mandal Commission. Before that, in 1955, there was a commission called Kaka Kalilkar Commission, which had undertaken this exercise, but unfortunately, Kaka Kalilkar Commission's report was lying in dustbin, absolutely. Nobody did anything with that report. Mandal Commission gave the report, but the report came to be accepted almost after a decade. And when VP Singh was the chief prime minister, that's when the Mandal Commission report got accepted, and certain communities other than scheduled caste and scheduled tribe were also brought under the ambit of what is called the affirmative action. And what we normally call them are other backward classes. These two executive actions were by an executive memorandum by the central government. It was not by any constitutional amendment. Just as what we had the provision in Champakam Dorai Rajan, which was sought to be overtaken by a constitutional amendment, there was no such provision of amendment. These were only two executive actions. These were challenged before what is called Indra Sani case. One question was whether this kind of reservation, can it be done through what is called an executive action. There were two memoranda. One which first said that so and so percentage shall be reserved. The second memoranda is also equally important because that is the first time that somebody thought of EWS reservation. So 10% EWS reservation is part of that executive memorandum, the second memorandum. So therefore that was the second part. So various questions were dealt with by that bench of 7 judges, or rather 9 judges. And one question was whether there can be reservation in promotion. So therefore that was one. Whether there can be, you'll be going close to the barrier of 50%, because the arguments were led by Palkhiwala in that case. And Palkhiwala advocated this, that look here, you already have 15% reservation for scheduled caste. You already have 7.5% reservation for scheduled tribes. So you go to the level of 22.5%. You are adding by the Mandal Commission report 27%, so you are getting close to what is called 50% barrier. You're just about 49.5%. There was one case which was decided by a constitution bench presided over by Gajendra Gadkar, and where he said that the barrier of reservation should always be 50%, nothing more than that. So that was that Balaji principle which was 50%. So therefore he said, yes, you are not overstepping that 50%, but you are getting very, very close to that 50%. As a result of which, what is going to happen is that the merit in this country will be sidelined for all times to come. And therefore, this is not giving equal opportunity to all the sections of the people. You are reducing the size of the cake for merit candidates. But that argument was rejected. One of the arguments was that whether these kind of OBCs, can they be part of the affirmative action? Can they be described as classes? Can they be described as what do you want as a community-wise representation completely? What was advocated was that community has been the denominator to describe when it came to scheduled caste, scheduled tribe, but not with regard to anybody else. All these arguments were rejected. The leading judgment is by Justice Jeevan Reddy, and a supplementary note by Justice P.B. Sawant, which is also beautiful. So all these arguments were rejected. One of the arguments was that whether there can be reservation in promotion, because once you say that the employment opportunities, there can be reservation, is the reservation to be confined at the first level of appointment? Supposing somebody gets appointed as additional district judge in the judicial service of the state, you are reserving certain seats, so therefore he gets through being part of that reserved community. Should he not thereafter get further promotions purely by merit? He must show his mettle that very well as a judicial officer I have done something remarkably well, and therefore I am entitled to promotion. So therefore one school of thought was that reservation at the initial stage should be the norm, not at the stage of promotional channels. So therefore if that additional district judge is to be appointed as a district judge, there should not be a reservation of seats at the promotional level. There was one judgment which was called Rangachari. And in that judgment, the Supreme Court had said that yes, it can be done even at the promotional level. Because the expression used under Article 16 is appointment. And appointment can mean the initial posting, initial appointment, as well as the promotional opportunity. The correctness of that Rangachari was also challenged before Mandal bench, that is Indira Sani. And Indira Sani says, Justice Jeevan Reddy, that such an idea that even at the promotional level you can grant reservation is not a good idea. So it is bad, we set it aside. So they set aside Rangachari. And then they said that yes, it has to be done only at the initial level, not at promotional levels. But they said that entire country has reconciled itself to the principle of Rangachari. People have received promotions at reservation at promotional levels. So we won't like to upset the apple cart, but we give various states 5 years to complete the process, and then thereafter reconcile everything in accordance with our judgment. So Indira Sani, 50%, normally yes, but it can be exceeded in given circumstances. That was one logic. Number two, yes, there can be OBC reservation. Number three logic, yes, not in promotional channels. So therefore these are three basic ideas which emerge from Indira Sani. So 5 years period, which was the twilight period which was given to the state governments and various legislatures to make amends. Very well. Indira Sani is perhaps 92. So judgment comes in 92. They have chance up to 1997. Very well. Alongside Indira Sani comes what is called 73rd and 74th Amendment. 73rd and 74th Amendment, if you look at 330 and 332, initial idea was reservation for scheduled castes and scheduled tribes. At what level? Lok Sabha and legislatures of state. What happens at the lower levels? Village panchayat, municipal councils, municipal corporations? Nothing. For the first time, chapters 9 and chapter 9A, 9 was completely modified and 9A was introduced. Two chapters get introduced by way of 73rd and 74th Amendment. which speak of village panchayat and which speak of the second chapter deals with what is called municipal council. What was Mahatma Gandhi's idea? Mahatma Gandhi's idea was that village panchayats should be the base. That people must have equal participation on democratic principles in electing who should be their rulers. And village panchayats indirectly must then elect the members in the what is called legislative assemblies or parliament. So his idea was that at the grassroots level there must be participation. What we adopted as a model was direct election to members of parliament, direct election to legislative assembly. Village panchayats, constitution as originally enacted, did not touch upon that subject. So for the first time, 73rd and 74th amendments spoke of what should be done at village panchayat and municipal council levels. And it had two articles. Number one, which says that seats shall be reserved for scheduled caste and scheduled tribe in proportion, what is their proportion, and for the first time, seats are supposed to be reserved for women as well. So in the political structure, scheduled caste and scheduled tribe, like what they had in members of parliament, members of legislative assembly, also at village panchayat and municipal council level. In addition to that, one category, which is women, which would also have reserved seats at village panchayat and municipal council level. So, originally only scheduled caste and scheduled tribe. Third got added, which was OBC, through interpretative process, not through constitutional amendment. The fourth category as a beneficiary of affirmative action which gets included is women. And there now you have 1/3 seats which are reserved for them under village panchayats and in municipal councils. The very same thought is now part of 106th Amendment, where in members of parliament, Lok Sabha, again you have 1/3. In legislatures, state legislatures, women will have 1/3 seats which are reserved for them. So the same principle, it got in a reverse way for scheduled caste and scheduled tribe, from top to bottom. For women, it got from bottom to top. So but the idea of reservation is same. So therefore, this is what the fourth set of beneficiary, which is the women, which are part of what is called the affirmative action now, in the form of separate reservation for them. That was 73rd and 74th Amendment. 5-year period which was given in that Indira Sani was to expire in 97. In 95 comes an amendment and 16(4)(a) gets introduced in the Constitution. I think it is 81st Amendment, if I mistake not, 81st Amendment. 16(4)(a) now says, even in matters of promotion there can be reservation. So this was a direct result of what is called Indira Sani fallout. Indira Sani gave the states 5 years. Sorry, we will not do that. Parliament's response was that even in matters of promotion there can be reservation. A clear-cut, specific incorporation of an idea in the form of 16(4)(a). Very well. So therefore that's the immediate response. Then, some of the decisions of the Supreme Court, Ajit Singh 2, then there was that, I don't recollect the name now, Ajit Singh 2 and some other decisions which actually spoke of what is called the reservation at promotion level, how is going to be read like this. So therefore, imagine a situation if A, B and C are 3 persons at the lowest level. A, B, C, D, E at the lowest level of the ladder. A, B are forward communities, C happens to be a scheduled caste, and D and E are again forward community members. And at the next level, avenue for promotion opens up. and 3 persons are to be picked up. A, B, C get picked up. Why? Because 1/3 seats are reserved for scheduled caste. Or even 2 seats are there. A and C get picked up, B gets left behind. And B gets subsequently promoted to that level. So Supreme Court in number of decisions, Veerpal Chauhan, Supreme Court in number of decisions like Ajit Singh Veerpal Chauhan said, that if the person was originally senior at the lower level and then reaches the level above, then he must regain his original seniority. So this concept of original seniority was coined by the Supreme Court, saying that otherwise the entire process will become very, very sort of oppressive for that man. Because B got left behind merely because promotion channels were not open for him. And there was reservation for somebody coming from scheduled caste, who was actually his junior, but now becomes his senior. So therefore, how does this actually sort of, be consistent with what is called Article 14 principle of equality and fairness? So therefore, Supreme Court, decision after decision, 3 constitution bench judgments, said that the man must get his original seniority. The response by the Parliament. Again, 16(4)(a) suffered one more amendment. And the amendment was that yes, it shall apply in matters of promotion with consequential seniority. With consequential seniority means what? That out of A, B, C, if C was scheduled caste candidate and only A and B got promoted, but because C got promoted earlier in point of time, C will have that consequential seniority over B, though B may get promoted later. So therefore, we have had scenarios like this, that somebody who was a junior now becomes a senior or becomes a level higher. But this is something which, according to Parliament, has to be the logical consequence of what the reservation in promotion has to be undertaken. And this is what their approach was. So therefore, look at the way there has been a tussle at times between Supreme Court and the Parliament. The first manifestation was Champakam Dorai Rajan. The second manifestation was Indira Sani, that you incorporated 16(4)(a). Very well. The third manifestation, you say original seniority. Sorry, gentlemen, we will have what is called consequential seniority. So therefore, this is how the approach of the Parliament has been to see that the affirmative action which is sought to be extended becomes meaningful, becomes substantial. Why? Because the debates in those days actually show, and they say, that if you have this idea of original seniority, the person who gets promoted, scheduled caste person, can never reach the higher levels. So therefore, in order to have good representation in the hierarchy of administration, you must have at all levels. At all levels, there must be adequate representation. It is only through such mechanism that you will have what is called, in true sense, affirmative action implementation. So therefore, this is what the approach of the Parliament has always been. Very well. So therefore, 16(4)(a), we stopped at that level. Then comes a very interesting development. Moini Jain was one judgment where, of course, the genesis is in, first is Maneka Gandhi 78 saying that Article 21 means meaningful life. Very well. So Moini Jain and Unnikrishnan then formulated a principle which is to say that if every person is entitled to have a meaningful life, that is to say opportunities to reach the highest potential as an individual, then you must extend to the community or the society the opportunities of education. And therefore, the basic education or primary education must be compulsory. This is what was advocated by Unnikrishnan. Unnikrishnan came in 1993. So by way of interpretative process, Supreme Court says Article 21 will include right to primary compulsory, free compulsory education. The response of the Parliament. Parliament adopts it in 2002 by way of constitutional amendment and incorporates 21 capital A. So it's not always an approach of tussle. Tussle was there whenever they felt that yes, perhaps I think there is an infraction or there is an inconsistency or there is a shortcoming. But when they found that the Supreme Court has actually opened the gateway for us, and this is the right approach, 21A gets incorporated. And now every child in this country is entitled to have free and compulsory education, whether it be in any nook and corner of the country. One more set of beneficiary gets added, which is children now. I jumped the gun and told you about 106th Amendment, but before that comes 103rd Amendment. And 103rd Amendment seeks to incorporate two sub-articles, number 1, 15.6, 16.6. It identifies one more category of beneficiary, which is, say, EWS, economically weaker sections. You know, when that matter was being argued before us, a very beautiful expression was given to this EWS category as Sudama category. That is somebody who comes from forward community but is economically completely in a weak situation. So therefore, it is that EWS category, and the definition is such by which it says that somebody who doesn't belong to scheduled caste, doesn't belong to scheduled tribe, doesn't belong to OBC, non-creamy layer, is not part of EWS. So EWS is, for the first time, forward communities of the country were identified on the strength of or on the principle of economic weakness to be set of beneficiaries. While every time you would see that who are supposed to be the beneficiaries, the persons at the lowest level of the ladder in the societal hierarchy. Here the persons who are at the top level of the societal hierarchy are also considered to be set of beneficiaries for extending affirmative action. And that is what EWS contemplated by way of 103rd Amendment at both levels, educational opportunities and public employment. How much reservation? 10%. So 49.5 plus 10%. You go to 59.5. And that's exactly what the challenge before us was. In a bench of 5, the matter came up. And I must say that this is something which is a remarkable tribute to professors. I have never seen, I have spent something like 40 years in Supreme Court. I have never seen a professor of law leading the submissions. And Dr. Mohan Gopal was associated with National Law School, Bangalore, National Judicial Academy, was leading the arguments. And followed by Dr. Mohan Gopal, mind you, is not a senior designated counsel. And followed by a number of senior counsels then thereafter. It was a very welcome sight to watch. A professor leading the arguments before a bench. What was the argument? Number 1, Constitution does not recognize forward communities to be set of beneficiaries for affirmative action. There is not a single article in the Constitution which would indicate that they can be the beneficiaries. There are a number of articles, scheduled caste, scheduled tribe. There are a number of articles which is SEBC, which was the subject matter in Indira Sani. But there is no such article in Constitution. This was sought to be put by a second memorandum which was subject matter of challenge in Indira Sani, which was not accepted by the court, rejected by the court. Now you're putting it through what is called constitutional amendment. So not recognized class, defeated attempt, exceeding 50%. Because now you will have 59.5. And in that extent, you're reducing the chances of those persons who are scheduled caste, scheduled tribe, OBCs to get considered in that open merit quota. Because open merit quota, the size of that cake otherwise would be 50.5% for everybody regardless of community. So those who are meritorious candidates, for them the quota, the size of the cake was 50.5%, now gets reduced to 40.5. So number one, they get excluded from that 10%. Number two, size of their cake goes down. Number three, not recognized as a beneficiary class. And number four, you are exceeding 50%. Of course, our judgment is in minority. We took a different view. But the majority judgment has accepted 103rd Amendment to be a validly enacted piece of amendment. So now, ladies and gentlemen, what we have is what scheduled caste, scheduled tribe, original constitution. OBC comes by way of Indira Sahni judgment, acceptance of that. Women come by way of say 73rd and 74th Amendment, third class of beneficiary. Fourth class of beneficiary comes, third class is OBC, scheduled caste, scheduled tribe, OBC. Then fourth class is women. Then the fifth class is what we call children, who come by through 21A. And the last category is EWS. So our ethos, our constitutional jurisprudence has now expanded to what level? As Professor Rao said, that constitution is a living document. It doesn't get old. We get old. Constitution doesn't get old. It just sort of, comes through the process of rejuvenation. So in that process of rejuvenation, what have our parliamentarians, our representatives thought? Number one, yes, originally we started with scheduled caste, scheduled tribe. That may be a limited agenda for us. And we can't be gobbling up something which we can't chew in one go. So therefore, let's go step by step. So scheduled caste and scheduled tribe, that was the set of beneficiaries. Then we expanded the net and went to the level of what is called OBC category. Alongside, we wanted to give representation to women in what? In political power structure. So therefore, 73rd, 74th Amendment. Then children, then EWS. Who is the next person? We don't know. So therefore, as of now, perhaps I think this is an ever-expanding kind of bracket situation. The bracket can get elongated, can get longer at any juncture. Depends upon the situation, depends upon the present day, or as it may obtain on any future day. What do we learn out of this? That the affirmative action under our constitution, though to start with was limited, has now achieved what is called a purely expanded form, where our parliamentarians, going by the present day situations, in their estimation, if certain communities, if certain classes also deserve a helping hand, they have chosen to extend that. They have chosen to extend it subject-wise also, qualitatively as well. When it came to promotion, they said, sorry, not the original promotion, original seniority, but consequential seniority. If Indira Sahni said, not in matters of promotion, we say even in matters of promotion. So they have made whatever is the extent of affirmative action bolder, clearer, and sort of more meaningful. So this is where you are now going to attain that level. I must tell you, in terms of statistics, I had the occasion to consider one matter coming from Karnataka. And in that, some of the statistics which were given was that if you have group A, B, C, D, these are the 4 categories of services under any state. you will have highest concentration of scheduled caste and scheduled tribe in group D, which is at the lowest level. And the concentration keeps on reducing as you go up. Now, this is something which is a stark reality. And if you want to give clear representation, meaningful and real representation to certain sections of the society, then those persons must also have the equal opportunity to reach the highest levels of the ladder. And this is what all our affirmative action is actually designed for. You know, by way of comparison, if you study this, our educational sector, how has been the approach? Champakam Dorai Rajan, that sorry, there should not be reservation, was set aside by First Amendment. So we are in the realm of post-First Amendment, where we have accepted as a notion, we have accepted as a community that yes, there can be reservation in educational institutions. What has happened to America? Americans go by what is called Champakam Dorai Rajan era, that there shall not be any reservations. But there were medical schools, there were law schools, which were desirous of admitting students coming from various communities under what is called the banner of having diversity on my campus. And decisions of the American Supreme Court in Bakke and other cases accepted that as a principle of admission, proper admissions. So Harvard Law School would admit students coming from various communities beyond their proportion. The recent statistical data actually shows that Asian Americans, who constitute just about 3% of the population, have more than 11% admissions in their campus all over the country. And this is why the recent judgment of the Supreme Court has annulled everything. It now says that this idea of diversity on campus is not a good idea. So they have gone back to what is called Champakam Dorai Rajan. But that's what some of the jurists actually criticized the American Supreme Court for their two recent decisions. Number one, on what is called this particular facet, and number two is abortions. So these two decisions are considered by jurists to be sort of, going back in time, not going forward. Whereas our jurisprudence is, which is always getting forward and forward. So therefore, every time we are evolving to see that the entire idea of affirmative action, not only the net gets wider, but it is more meaningful, more substantial. Thank you so much. Thank you.
It's so brilliant. Indira Sahadi's concept of creamy layer. How do you look at it?
See, what happened is the discussion goes like this, that there are communities which are, say, scheduled caste, scheduled tribe, where a person who is born untouchable, centuries of oppression. So my grandfather, great-grandfather, his father, his great-grandfather always did this job, nothing else in life. So it gets stamped on the forehead. Once it gets stamped on the forehead, in order to identify a community as a beneficiary, our constitution accepted what is called scheduled caste and scheduled tribe to be the communities regardless of their economic status or societal status which a particular individual may have attained in life. For instance, a scheduled caste person who, as a result of affirmative action, climbs up the ladder in the societal structure, his children, son and daughter, would they be entitled to the same kind of affirmative action? There we have accepted the fact that because he belongs to that community, there is a stamp on his forehead, and therefore, as a member belonging to that community, he must be entitled to that affirmative action. That's exactly what, say, Jagjeevan Ram, who always enjoyed the power. He was always a minister. His daughter Meera Kumar got into IFS through what is called quota for, or the reservation for scheduled caste and scheduled tribe. Regardless of such, because they belong to a particular community, they must be given that advantage. Very well. So this is what our constitution has recognized. That is exactly why 341, 342, you have a presidential order which describes who are the scheduled caste, who are the scheduled tribes. Is there any such status for OBCs under the constitution? There was none when the matter was considered by the Supreme Court. So therefore, where do you fit in OBC in the constitutional structure? It gets fitted only under what is described as socially and educationally backward communities. Now, socially and educationally backward communities, or SEBC as the short form goes, can include scheduled caste, can include scheduled tribe. Now, if you see the distinction between the language used in the articles, 330, 332 specifically use the expression scheduled caste and scheduled tribe. So the reservation is only for them in Parliament. There is no reservation for OBCs in Parliament. So reservation in Parliament is only for them. When it comes to 15 and 16, the expression is socially and educationally backward communities. It is not confined to scheduled caste and scheduled tribes alone. So therefore, the width of that expression is definitely larger, definitely wider than scheduled caste and scheduled tribes. Very well. So therefore, this is where you wanted to fit in OBCs. Where do they come in? Where is that constitutional sanction for such kind of executive memoranda? That was one of the questions which came up before Indira Sahni bench. But then came the idea that when you say socially and educationally backward, now take for instance, who are socially backward? Those who are in the lowest levels of that ladder or the hierarchy? This is what Mahatma Jyotiba Phule was trying to educate them. Why? Because they were deprived of that flame of education, the benefit of education. They were what is called the criteria where Shudras were never given the benefit of education. They were considered to be complete outcast. So because of your social backwardness, you entered what is called an alley of educational backwardness. And because you are socially and educationally backward, the third fallout of that is that you are also economically backward. Because it is true, if you are at the lowest level of the society, socially backward, you don't have the benefit of education. Can you imagine somebody rising on the economic front? So the fallout is that because you are socially and educationally backward, the consequence of that will always be that you are more probably supposed to be economically backward as well. Correct? So this is the logic of that. But now take for instance, Mandal wanted to give benefit to certain communities which were up till now not part of the circle of beneficiaries. Now take for instance somebody who is a goldsmith, is a Vaishya in the societal structure. Somebody who is a carpenter is a Vaishya in societal structure. Some of these communities were also picked up in Mandal because they continued to be backward on the social front. So therefore, in order to equalize something, in order to have a parameter where you can now identify somebody as set of beneficiaries who are actually entitled to, who must be given this helping hand. So therefore this concept of creamy layer was brought in the judgment of Indra Sahni. What is creamy layer? Creamy layer is that if your income, family income is more than, say, a fixed kind of level, maybe say 5 lakhs, 10 lakhs or whatever. Creamy layer is if one of your parent is actually at a level in the governmental apparatus, at a level above the level of secretary, deputy secretary or somebody. Creamy layer is also that if you have certain level of, parents etc. had level of education. So therefore what you are trying to confine is, and why, I'll just give an example. Most of you must have done, everybody who is entering law college, you have gone through the 10+2 level. At 10+2 level, when there are coaching classes, there are special tuitions, there are various opportunities, what do your fathers and mothers do? They try to give you laptop, they try to put you in a coaching class, they try to give all kinds of, facilities to you. Mother will try to give you goodies every time so that, you are nourished well, so that you can take up the burden of, studying so much. So the entire family looks after you. This is something which you do it, why? You do it through the process of your economic advancement. Because your parents have reached a particular level. So if this particular level has already been reached by a family or a household, then the child will not be deprived of the opportunities. The child will be provided with certain levels of opportunities. And therefore, for such a child to be then saying that I must have reservation also is not a good idea. And that's why when it came to OBCs, scheduled caste, scheduled tribe, we have a different parameter. Why? Because what is taken is that the parents are still under that, the influence of being born in that community. So therefore the mother will certainly be slightly disadvantaged. The father, though, may have gone up in the level of promotions in the governmental apparatus, but still he is considered to be coming from that backward community. Whereas OBCs will not be. And therefore that level which was one sort of thin line which was drawn by the Supreme Court was somebody who is called, what is said, creamy layer. If you are part of, in that community, part of what is called creamy layer, you are above a particular level in the society, then you don't need that helping hand, you don't need that affirmative action. And therefore, the affirmative action must be available only for those who come from non-creamy layer in OBC category. That's all that I can.
I will only say one thing. What a great loss to the academic world by Justice Lalit opting for litigation advocacy and a career in judiciary. The gain to judiciary and litigation advocacy is a terrific loss, but now he has come back with renewed vigor. He is associated with UNL as Director-in-Chief. We are grateful to you, sir, for having accepted the request of Honorable Chairman Dr. Manan Kumar Mishra, the foresight of Manan Kumar Mishra ji, because earlier when we met once, he was telling, oh, Mananji, after my brandy, this is what he was telling. And we always look forward to your blessings. And to date, I can say this has been the best election that I have heard in. I got a genuine, even a bit. Okay. So some of the youngsters may ask some questions. Yes. So the house, yes, I know, I saw your hand. Okay.
Good morning, respected Lordship.
Introduce yourself.
Okay, my name is Katyayani Singh and I'm from first year BA LLB student, and it's an honor to be in your presence. So sir, In our recent studies in jurisprudence with our respected Dr. Abhik sir, we delve into the history of segregation and cases such as Linda Brown, drawing parallels between the discrimination faced by the blacks in the USA and the untouchables in India. Considering the extensive and flawless constitutional safeguards introduced for the scheduled caste and scheduled tribes and the affirmative actions provisions implemented, how do you perceive the role of judiciary and the law enforcement in addressing the historical and ongoing issues of untouchability and brutality by the police officers, such as custodial rape and harassment on these groups? Furthermore, in the context of our learnings on segregation, how would you compare the approach of the Indian judiciary to that of the United States in dealing with issues of discrimination, particularly regarding affirmative actions? Thank you.
This itself can be a topic for a lecture. Anyway, now what happened in American, please take your seat. In US, as I told you, the whole concept is they are still under what is called Champakam Dorai Rajan era. Correct. According to them, what is equivalent 14th Amendment does not contemplate or does not admit of any such distinction or differentiation, correct, on the grounds of coming from communities, etc., etc. But traditionally what used to happen in US is that certain households were typically what is called white households, and certain areas where what we normally call the black kind of areas which are meant for their houses. So at some level, according to the American Supreme Court, this segregation is also a good idea so long as in that segregated area your treatment is equal to that particular class. So mark it this way, that if there is a black household, you are treating all blacks alike in that area, correct? So segregation, according to the American Supreme Court, was an acceptable norm, and it would not violate what is equivalent to our Article 14 or the concept of equality. The same idea of segregation also percolated when it came to schools. There were high schools, there were primary schools, which were meant for only whites. There were schools which were meant only for blacks. Similarly, there were certain universities also which were typically what is called black universities. So this for some time was an acceptable norm for them. As a result of which what happened is that all of those persons were put in that segregated chamber, if I may use that expression, or a compartment. There was no interspersing, that is blacks joining the white schools or whites joining the black schools. Then there was a shift, and then they said that this idea of segregation is something which is not acceptable, going by the very principle of equality. As a result of which what? As a result of which now the black students can get admitted in white schools. Vice versa has never happened according to their social scientists, correct? The white students have never taken admissions in black schools. The reverse has happened, but the other part has never happened. But as a result of this non-segregation as an idea, there is more integration in the society, correct? American Defense Forces, you'll see most of them are comprising of whites as well as blacks. So there is no segregation. In our society, actually, when it comes to defense forces, there are certain regiments which are actually for those persons. Like say for Mahar Regiment, which is one of the premier regiments, which has given some of the generals, is only for Mahars, which is the scheduled caste in the societal hierarchy. So this was notified as Mahar Regiment. There are Rajput regiments. So therefore we have gone by that. Though we consider it to be non-segregated society. But they used to have that segregation as a principle, as an acceptable norm, which they have now given a go by. Now, as a result of which now, say, for instance, people say that it was Martin Luther King who raised the voice for the first time. Nelson Mandela then started running, and ultimately Barack Obama became the president of the country. So therefore, this is how it happens through what is called non-segregated society. So therefore, this is how the opportunities must be open to everyone. Now, so far as individual cases of oppression are concerned, our legislation, which is that 1955 legislation, actually speaks of, it has got tremendous amount of teeth. So therefore, it can certainly reach at every individual aberration, every individual kind of inconsistencies. Now, what the judiciary has to do, what shall be the approach of the judiciary? The judicial approach has always to be, decide a dispute going by the rights of the persons. According to me, at no stage there is not a single judgment, even by a high court, saying that a person coming from deprived classes of the society is not entitled to something. We've always actually found that yes, the entitlement is there. How best do we subserve that? Correct. So therefore, according to me, this perhaps could be the answer to your question. Yes.
Thank you so much, sir.
I would like to.
He's Abhishek Krishna, our colleague, sir.
Hello. Yes.
I would like to know the future of affirmative action, given the space of state activities ever reducing, and then the private sectors are increasing their participation. We are saying that there are now attempts by the governments to reserve places of jobs in private sector because the economic policy has changed a lot. So what do you see the future? Because I see the two limbs that you have described is the educational limb of the affirmative action and the pie in the job public affairs and the popular. So in the public job scenes, do you see that the impact of ever increasing the capitalist society would reduce the affirmative actions, and should there be encroachment by the state in the private affairs too, with regard to jobs and other economic opportunities?
Let's divide this in two categories: educational opportunities and public employment. One of the articles which I did not, because paucity of time, I did not cover that. One of the limbs of 15 is that there can be reservation even in educational institutions which are in private sector, correct? But which are receiving, whether they are receiving aid or not. So therefore, the width of that affirmative action is also travels to such levels. That is to say, not confining itself to government-run schools or schools which are receiving aid. Even unaided schools can also. What was that fallout? This came in 1995, correct? TMA Pai said that when it comes to unaided schools, they are not within the control of the government when it comes to who shall be admitted, etc., because that is part of your 19(1)(g) right as well as your right as an institution. In order to get over that difficulty, this idea was introduced in 15. Very well. So therefore, educational institutions, even in private sector, can also be subject matter of affirmative action. When it comes to 21A by itself, the text of that article doesn't say anything. But the Right to Education Act also says, and this is what that Modern Education Society Justice Kapadia's judgment, that even with respect to private sector schools, there can be a compulsion that you must admit 25% students coming from, say, a reserved category of students, correct? So therefore, the affirmative action is not something which the Constitution speaks of. Therefore, I did not touch upon that. It is the legislation which touches upon that, correct? So 15 is something, one area. Let's now deal with 16. 16 is employment. Now there is a legislation which speaks of persons with disability. For persons with disability, there can be reservation, which is to the extent of 4% or 5%, correct? Now that extent of reservation can also be in what is called private sector undertakings, not necessarily in all public sector undertakings. So therefore, if there is a corporate entity which is actually in business, it can also be subject to the idea that you must reserve some 3 or 4% or 5% seats for physically or otherwise handicapped persons. What is that? That's also an affirmative action, which is extended to somebody who is in a disadvantaged condition, maybe somebody who is mentally challenged or physically challenged or maybe visually challenged, whatever it be. Now we have gone to the extent of saying that even in police you must admit them. So therefore the affirmative action is what? Now you are, every time you are having one more set of beneficiaries. You're constantly sort of, your eyes are open, your ears are also open. What is happening in the society? If these are the persons who require some kind of helping hand, then we must do it. Why I did not touch upon that? Because it is not constitutionally sanctioned. Correct? Constitution doesn't speak of that. Legislation does. Legislation does. Correct? Whether on that ground there can be a discrimination is something which had come up before the court. That's a different idea. But the text of the Constitution doesn't speak of that. But therefore now what we will find is 15 is getting expanded, 16 is getting expanded. So therefore, if you ask me what is the future of affirmative action, we'll always have, it's only the future which can tell you what exactly is in store. But I must say that going by the experiences that we have learned, perhaps I think there is still room for somebody else to be considered as beneficiary of this affirmative action. Thanks.
Yeah. We'll come to you, Ashwin. You will be the last one, okay? Next.
Good afternoon, sir. So my question is, do you think that the LGBTQIA plus community would ever come under this bracket of affirmative action in our country?
Theoretically, yes, but I have my, if I may give the counter argument, not to belittle the idea, but see, my birth in a community is something which is beyond my capacity, is not under my control. If a person gets born to parents who are scheduled caste or scheduled tribe and therefore stands in a position of being negated the advantages of advancement in life, then he stands on a different footing. My sexual orientation is my choice. Correct? It has not been thrust upon me by accident of birth. Whatever is my sexual orientation is a matter of choice. So it is not through that sexual orientation that I stand deprived of, except where perhaps somebody who has been born as neither a male or a female. Correct? What are called the born third gender categories. There it is a matter of accident of birth. So therefore certainly yes. But then most of these LGBT, whatever that community is normally called, they are all, their orientation is their own choice. Their own choice, and they have adopted it as a choice. Nonetheless, I don't think that perhaps, I think there would be negation of the idea that perhaps in future they can also be part of what is called the affirmative action to a certain extent, yes. But the reservation has to be, see, I did not touch upon this because the constraints of time. The reservations that the Constitution has recognized, number 1, scheduled caste, number 2, scheduled tribe, number 3, OBC, these are vertical reservations. So therefore a person who is OBC can't be scheduled caste, can't be scheduled tribe. Correct? These are vertical compartments. Somebody who is scheduled caste can't get admitted as scheduled tribe or OBC. So it's a vertically separate compartments. Whereas horizontal reservation, which is for women, a woman can be scheduled caste woman, a woman can be scheduled tribe woman, a woman can be OBC woman also. Similarly, physically handicapped can be horizontal reservation. Similarly, LGBTQ, that can also be a horizontal reservation. So horizontal reservation, then what it means is to the extent of that, you will be actually taking a slice out of whatever is available for individual vertical column. Now take for instance, if we accept 49.5% to be the reservation. Now the fourth column which got included is EWS, which is again a vertical column, correct? So therefore 49.5, rest is 50.5. The moment you had one more column, you have eaten into that, which means it is now only 40.5. But whereas if you have horizontal, which means that there can be a woman who can be in open category going purely via merit, there can be a woman who can be scheduled caste, there can be a woman who is scheduled tribe, OBC, or even EWS. So that traverses through horizontally everywhere. Similarly, perhaps I think this LGBT category can also be through horizontal reservation. But that's a matter for the parliament to consider. Nothing wrong in considering a particular group as a group. I'm only giving you as my initial reaction. Because there is certain compulsion which gets visited upon. Even with that EWS category, this is what the very beautifully submitted by one of these council is that he said, at times your EWS status is a matter of accident. Correct? Pandavas turned pauper in one single day. So they were, from that day onwards, they were what is called EWS category. Now somebody who was able-bodied, somebody who was the most sort of able warriors, they were actually part of EWS category. So therefore these are accidents of life. Certainly yes.
Good afternoon, sir. So my question is that how can we strike a balance between addressing historical injustices and also considering that affirmative action, for example, adding beneficiary over beneficiary, so that it does not result in promoting mediocrity over merit. For example, you also mentioned that reservation at promotional levels. So how can we strike a balance?
See, this has always been the tussle. This is exactly what Palkiwala had argued, saying that you are cutting the slice of the meritorious candidates, correct? Now imagine a situation. In good old days, there used to be only 6 IITs in the country. Bombay, Madras, Kharagpur, Kanpur and Delhi. 5 and Banaras Hindu University. Only 6 IITs. With the passage of time that you are now admitting students in SC category, ST category, OBC category, you have expanded the scope now. Now how many IITs are there? At least 20 of them. How many IIMs are there? Initially only 3. How many now today? About 12 or 13 IIMs. How many national law schools? Initially only National Law School at Bangalore. So you are expanding your opportunities as well. So the scope of opportunities is getting also wider. So it's not as if that the size of your cake has remained constant. Size of the cake is also expanding. So therefore the opportunities for those who do not belong to or who do not come under any of these categories, for them also the size is expanding. So therefore, when you say deprivation of opportunity, it is not actually deprivation of opportunity.
Sir, my question is, could we also conceive an affirmative action that is intersectional? Because even in terms of horizontal and vertical reservations that you've spoken about, when we come to gender as a category of reservation, realistically speaking, the Savarna woman is more likely to have an advantage over the Dalit woman. And when it comes to caste-based reservation, the man, owing to gender, is more likely to have an advantage over the woman within the community as well. So when is it that our affirmative action, when we were conceiving the idea, was as if different vectors of privileges and disabilities operate in isolation, and then we have that kind of a scheme, whereas in reality they actually intersect, and the lived reality of a person comes from that intersection. So when you spoke about horizontal reservation, now it's possible that the Dalit woman might get the chance, but there is no way to guarantee it. So can we also have an affirmative action where we acknowledge the intersection as well?
See, if there is a blackboard here, I can immediately sort of, tell you how the horizontal and the vertical reservations actually ensure that the women do not get a raw deal. Correct? So therefore, if you are now going on this principle that sectional, the women, are they getting a raw deal? No, they are not. Now let me give you an idea, just orally. Let us put it that there are 100 seats in a medical college, 100 seats for admission. And let's put it this way, that we are in pre-EWS category. So 50 for reservation and 50 for open, correct? So out of 50, 17 are supposed to be, or 18 for scheduled caste, 7 for, say, this scheduled tribe, and rest for, say, OBC. Let's put it this way. Now, how would you normally admit students? The normal way of admitting the students is take first 50, put them under open category. Regardless whether out of that 50, 12 are scheduled caste, or 7 are OBC, or 3 are scheduled tribes, it makes no difference. Because they are walking in purely on account of their merit, sheerly on the basis of their merit.